Imagine you're a technical sergeant. You run a tight-knit shop, morale is high, and the mission is getting done flawlessly.
Right.
You think you have a perfect handle on your people and your operation. But then, on a random Tuesday, an airman makes a restricted report of sexual assault.
Yeah, that changes everything instantly.
3 days later, another troop pops positive on a random drug test. And suddenly, 2 of your subordinates are under investigation for an unprofessional relationship. Almost overnight, you aren't just a mechanic fixing jets or a specialist running a network. You are suddenly a vital, load-bearing gear in the unforgiving machinery of military justice. Welcome to this deep dive.
Today, we're opening the Blue Suit files.
It is a brutal transition for a mid-level leader. You go from managing tasks to managing the clinical administration of consequence. And that's exactly what we're analyzing today, which is Chapter 20 of Air Force Handbook 1, Enforcing Military Standards. But we're looking at this strictly through the operational lens of a technical sergeant.
And to do that properly, we have to use the Airman Development and Testing Chart, the ADTC framework. Right.
Because it maps out exactly how deeply you need to understand these regulations. For the first half of this chapter, the inspection systems, the individual accountability, the Air Force demands a level B comprehension.
Which means you can't just memorize the rules.
Exactly. You have to understand the relationships between them. You have to grasp the why behind the machine.
And then for the second half of the chapter, managing relationships and administering punishment, it shifts to a level C comprehension. That's application. That's where you stop looking at the blueprint and you start operating the machinery in real-world leadership scenarios.
So to apply those rules, you first have to understand the machine that enforces them. Let's start with level B, the systemic architecture. Because before you can analyze human behavior, you really need to map the system designed to monitor it.
Well, the overarching architecture is the Air Force Inspection System,
Yeah.
AFIS, and the Commander's Inspection Program, the CCIP. The crucial thing to understand here is that the objective of these programs is not just checking boxes on a compliance sheet.
Right, it's not a white glove test.
Exactly. The system is engineered to assess risk, identify root causes of failure, and focus limited resources with absolute precision. It's an independent assessment process designed to measure what assigned forces can actually do, not what they claim they can do.
But for a system that massive to work, it requires very specific components, doesn't it? You need independent verification. That's where the Inspector General comes in. The IG acts as the objective eyes and ears of the commander.
Because they have to be removed from the normal chain of command.
Yes, to remove any perceived conflicts of interest, they are the honest broker in a system where people might be tempted to hide their failures.
And to keep the machine from grinding to a halt under the weight of its own audits, the system relies on gatekeepers. Their entire purpose is to synchronize inspection efforts. They maximize training days, align schedules, and ruthlessly eliminate duplication.
They ensure a commander's actual priorities always supersede non-mission essential activities.
Right. Which clears the runway for the specific high-stakes inspections. Take the nuclear surety inspection, or NSI. This evaluates a unit's ability to manage nuclear resources safely. And the clinical reality there is obvious.
The margin for error is exactly zero.
Zero. The extreme political and military consequences of a nuclear incident demand it. Then you have the broader unit effectiveness inspection, the UEI. This isn't just a snapshot. It's a multi-year external evaluation based on 4 major graded areas.
Managing resources, leading people, improving the unit, and executing the mission.
Precisely. But this is where the structural logic becomes highly consequential. A multi-year external audit can't be everywhere at once, so the system depends entirely on the unit self-assessment program.
Right, and they track that through the Management Internal Control Toolset, MICT, using what they call self-assessment communicators, or SXE.
Correct. SX asks airmen at the absolute lowest shop level to self-report their compliance or non-compliance. The system is explicitly designed to foster a culture of critical self-assessment.
Okay, wait, I have to stop here. Because I look at the MICT and SAC self-reporting system, and it functions exactly like a vehicle's onboard diagnostics. It's the check engine light.
It's a good way to look at it.
But if the system relies on the airmen themselves to safely report non-compliance, isn't it essentially asking the engine to report its own failure before the mechanic even opens the hood? That feels like a massive structural vulnerability. The text relies entirely on truthfulness over expected answers.
It is a vulnerability, and it's analytically significant. The text explicitly states that the purpose of the program is to make airmen feel they can safely report what is true, not what they believe their commander expects to hear.
But think about the human element there.
Exactly. If fear of reprisal overrides that commitment to truthfulness, the onboard diagnostics feed false data to the mechanic. The entire commander's inspection program becomes invalid. The system only functions if the individual component, the airman, inputs factual data.
Which perfectly explains why we have individual accountability systems to protect that data flow. I mean, the Air Force Complaints Resolution Program exists specifically to correct those programmatic weaknesses. It guarantees members the right to present complaints without fear of reprisal.
And it enforces that with strict whistleblower protections. Look, it is crucial to note that only the IG may investigate allegations of reprisal and restriction under the Military Whistleblowers Protection Act, but the system is clinically objective.
Meaning mere dissatisfaction isn't enough.
Right. Mere dissatisfaction with the outcome of an alternative grievance process is not a sufficient basis for an IG investigation. You can't just be unhappy with the decision. There must be tangible evidence that the process itself was mishandled or weaponized.
And that individual accountability extends far beyond just reporting shop-level compliance. It bleeds directly into strict behavioral prohibitions. The system heavily monitors the individual's actions, even outside the gate. Take the prohibitions on political activities under Department of Defense Directive 1344.0 and extremist activities under Instruction 1325.06.
The regulations here are absolute and uncompromising. Military members are explicitly prohibited from participating in partisan political fundraising activities, rallies, or conventions.
And this applies whether you are in uniform or not.
Furthermore, members may never wear their uniform at a political event, while making a public speech, or while marching in a rally. We have to be clinical about stating these prohibitions. Partisan advocacy is structurally incompatible with the uniform.
It also extends to ideological associations. Military personnel must not actively advocate supremacist, extremist, or criminal gang doctrine. That includes any ideology that advocates illegal discrimination or the use of force and violence to deprive individuals of their civil rights.
And engaging in those prohibited activities isn't just frowned upon. It subjects the member to immediate prosecution under Article 92 of the Uniform Code of Military Justice.
The clinical thresholds regarding substance abuse follow this exact same rigid structure, don't they? The metrics are binary.
Completely binary. A blood alcohol concentration of 0.08 is legally impaired. A concentration of 0.05 to 0.08 is presumed impaired and can be considered alongside other evidence.
And when it comes to drug testing, DAFMAN 44-197 outlines how the system actually catches that impairment. It deploys 4 distinct testing parameters.
First, you have inspections under Military Rule of Evidence 313.
Right, these are your random sweeps, conducted with or without notice.
Second, probable cause searches under Rule 315, which require direct authorization from a military magistrate based on specific evidence. Third, you have testing for medical purposes, where diagnostic tests can be used to identify abusers. And finally, self-identification.
And that last one is critical for the rehabilitation aspect of the system. If you voluntarily self-identify as a substance abuser before being caught, commanders may not use that voluntary disclosure against you in a UCMJ action. The machine rewards the component for reporting its own failure before it causes catastrophic damage.
So the overarching logic of Level B is crystal clear. As a technical sergeant, you are operating within a highly surveyed, rigorously documented machine. You have to understand the diagnostics.
But that brings us to Level C, applying the standard to leadership scenarios. Because the system relies on human beings, and when working relationships fracture, the system breaks.
This is where we shift from theory to consequence. The regulation establishes a critical divide between professional and unprofessional relationships. Professional relationships are vital to military operations because the mission fundamentally requires an unhesitating adherence to orders.
And we are talking about orders that may result in inconvenience, severe injury, or death.
Unprofessional relationships, on the other hand, detract from that authority. They create the appearance of favoritism, or they abandon organizational goals entirely for personal interests. The text notes that differences in grade inherently increase the risk that a relationship will be perceived as unprofessional.
Let's apply this directly to the UCMJ. We have to differentiate between fraternization under Article 134 and unprofessional relationships under Article 92.
Fraternization specifically defines an unprofessional relationship between an officer and an enlisted member. It puts the enlisted member on terms of military equality with the officer, prejudicing good order and discipline. The officer is held primarily responsible under Article 134.
But the text makes something brutally clear for the enlisted force. An enlisted member involved in consensual fraternization is still engaged in an unprofessional relationship and is entirely liable for discipline under Article 92.
Consent does not negate the regulatory violation.
Exactly. But what's fascinating here is the operational vagueness of the text. It states relationships become a concern when they, quote, are perceived to adversely affect morale. That perception is completely subjective. It places the burden of situational awareness squarely on you as the technical sergeant. You have to spot the fracture before the machine breaks.
And when those fractures escalate, they often manifest as harassment. The Equal Opportunity Program outlines 6 distinct forms of harassment recognized by the Air Force: discriminatory, sexual, bullying, hazing, retaliation, and reprisal.
Discriminatory harassment is based on race, color, religion, sex, and national origin.
Right. And sexual harassment involves unwelcome sexual advances or deliberate offensive comments of a sexual nature. It is viewed as so corrosive to the mission that it is now a specific crime under the UCMJ.
And when administering the EO complaint process, the timelines are unyielding. You can't just file whenever you want. Civilian complaints, processed under Title 29, require the initial contact to be made within 45 calendar days of the alleged discriminatory matter.
While military formal complaints must be filed within 60 calendar days of the alleged offense, the clock is unforgiving.
This brings us to the most delicate and heavily regulated human system, the Sexual Assault Prevention and Response Program, or SAPR.
The Installation Sexual Assault Response Coordinator, the SARC, is the single point of contact overseeing the response. And the Victims Counsel, the VC, is a military attorney authorized to provide independent, privileged legal representation to eligible victims.
The reporting mechanisms here are bifurcated into restricted and unrestricted reports, and understanding the difference is vital. A restricted report enables eligible victims to report allegations to specified personnel, like a SARC, a SECIPAIR victim advocate, or healthcare personnel, without triggering an investigation.
It provides the victim time and control over their personal information.
An unrestricted report, however, triggers an official, unstoppable investigation through law enforcement and the chain of command. You can convert a restricted report to an unrestricted one, but an unrestricted report can never be reversed. The machine cannot be turned off once it starts.
And we really have to examine the clinical fallout of failure regarding the Safe to Report policy. This addresses a massive barrier to reporting, which is collateral misconduct by a sexual assault victim.
Like, for example, if a victim was engaged in underage drinking or fraternization at the time of the assault.
Right. If the investigation reveals that collateral misconduct, the initial disposition authority steps in to determine if it is minor or non-minor.
If the authority determines the misconduct is minor, the Safe to Report policy applies. The victim will not be disciplined for the collateral infraction.
But if it is deemed non-minor, the policy protection evaporates. The victim could face disciplinary action for their misconduct. The regulation offers no leniency for non-minor violations. The mechanics of the policy are uncompromising and entirely detached from the trauma of the primary incident.
That clinical detachment raises a really interesting question regarding another form of harassment: bullying and hazing, because I want to push back on the text here. The regulation provides a caveat that activities for a proper military purpose, such as physical training or combat survival, do not count as hazing or bullying.
Yes, it does.
But if the definition relies on the intent of the aggressor or the perceived purpose of the activity, how does a technical sergeant apply the exact line between extra-military instruction and hazing?
It's a fantastic question. And the distinction lies entirely in the nexus to organizational goals versus psychological harm. Hazing involves creating a risk of physical or psychological injury for the explicit purpose of initiation, or as a condition for continued membership. It's tribal.
While extra-military instruction, however, must serve a direct, documented training requirement to correct a specific operational deficiency.
Precisely. So if a technical sergeant employs physical exertion to punish, humiliate, or initiate a new troop, rather than to instruct them or prepare them for command-authorized activities, the line is crossed. It ceases to be training and becomes a UCMJ violation, regardless of whether the victim consented to the rite of passage.
Which forces us right into the final stage of Level C, addressing misconduct. When relationships fail, when the standards are breached, you must apply corrective actions. This is the clinical administration of consequence.
And the tools of correction operate on a rigid scale of graduated discipline. It always begins with counseling, officially documented on a DAF Form 174.
If the behavior continues, it progresses to an admonishment, which warrants more severe administrative action.
Finally, it escalates to a reprimand, which indicates a severe degree of official censure.
But you can't just issue these actions on a hunch. The standard of proof required is a preponderance of the evidence. That simply means the greater weight of credible evidence. If you put it on a scale, it's 51%.
Right. It is a lower threshold than beyond a reasonable doubt. But if that greater weight of credible evidence is lacking, the administrative action is legally unsupportable. The paperwork will fail.
And you must track the fallout of these actions meticulously. The Personnel Information File, or PIF, is the baseline repository. But the Unfavorable Information File, the UIF, is entirely different.
It provides commanders with an official, highly visible repository of derogatory data. Mandatory documents in the UIF include suspended or unsuspended Article 15 punishments of more than 31 days, court-martial convictions, and control roster actions.
I always view the UIF and the control roster through the lens of a financial credit score. It is a ledger of your operational liability. The control roster, executed via DF Form 10058, is a rehabilitative tool that establishes a mandatory observation period. It is a mandatory UIF entry.
And it lasts exactly 6 months, ending precisely at 2,400 hours on the 6-month mark.
Once you are placed on the control roster, your institutional purchasing power drops to absolute zero for 6 months. You are frozen. If the member is not rehabilitated within those 6 months, the machine escalates to more severe action.
So let's apply this to a specific technical sergeant scenario. What happens when the mandatory 90-day commander review of a UIF intersects with an active promotion cycle?
Oh, it's devastating.
It is structurally devastating. During that 90-day review, or when considered for promotion, the presence of a UIF, and specifically an active control roster, action signals to the commander and the evaluation boards that the member currently lacks the reliability to assume greater authority.
The system is mechanically designed to automatically suppress the promotion of a failing component until the rehabilitation period expires and the operational credit score is repaired.
And if the component cannot be repaired, we look at the ultimate consequence: administrative demotions and separations. An administrative demotion is utilized for failing to fulfill responsibilities or failing to keep fit.
Separations are categorized by the permanence of service characterizations. Honorable is awarded when service has met acceptable conduct. General, under honorable conditions, is given when significant negative aspects outweigh the positive aspects of the military record.
And then there is the under other than honorable conditions discharge. This characterization is not given lightly. It is based on a pattern of behavior or severe omissions that constitute a significant departure from expected conduct. It requires the full weight of an administrative discharge board.
And if charges have been preferred and a punitive discharge is authorized by a court-martial, an airman may request an administrative discharge in lieu of trial by court-martial, but there is absolutely no guarantee the request will be granted. The fallout is permanent, life-altering, and meticulously documented.
We can synthesize the clinical reality of Chapter 20 right here. To operate effectively as a technical sergeant, you must possess a Level B comprehension of the inspection and accountability systems, AFIS, MICT, and IG protocols. You have to understand how the machine gathers its data and how it protects its whistleblowers.
You then take that understanding and elevate it to Level C, applying relationship management and graduated discipline. You must differentiate between fraternization and unprofessional relationships. You have to execute the forms, enforce the unyielding timelines of the EO and SAPR programs, and administer the consequences of the control roster without hesitation.
But I want to leave you with a final thought regarding Sections 20.29 and 20.30, the Air Force Discharge Review Board and the Board for Correction of Military Records. Throughout this deep dive, we have detailed rigid, cold, and immediate consequences. The machine acts swiftly. However, the system allows former members to request corrections to their discharge characterization or military records up to 15 years after separation.
That is a staggering paradox for you to ponder.
Yeah.
A system that's strictly enforced, utilizing objective metrics, gatekeepers, strict timelines, and preponderances of evidence, still structurally admits that its own clinical administration of justice might take a decade and a half to get right. We demand immediate precision from the engine, yet the mechanics openly acknowledge it may take 15 years to accurately diagnose and repair the failure. Unbelievable. We'll see you next time.